Someone make it make sense.
Probably a couple.
Hello and welcome everybody. Shout out to Flash Fan, shout out to Tennis Girl. Happy to see you guys. So we are here tonight for Shanna Gardner and the death penalty motions. So a couple matters of housekeeping though. Let's see here. Let me look at my notes. Okay, so one thing, I was going to answer one of Candace's questions from last night, which was about the victim's advocate and if she introduced herself or if the detective introduced her as a victim's advocate. And the answer is it was the detective, but don't worry because that clip will actually be in the Best of Glenn compilation video. So y'all will be able to see it for yourselves. Also, to Kitsmits, I wanted to make a note that she had mentioned last night that there was something she had said originally in the stream from, what was that, on Christmas night? And so she didn't answer the question again last night. And I wanted to note that the comment never appeared in the chat, which you probably could see if you watch it, when you can see what I'm seeing. Her response to the question about if you put your hands in front of your face when you're crying, that never came in the chat. Which I just thought was interesting because for whatever reason, it didn't pop up. So let's all remember that sometimes comments don't pop up in the chat. I don't know if it's YouTube blocking them or if it's something with StreamYard, but you can see there, she even says that she responded in the chat, but that response never pops up from what we can see showing you on my end. So that was another thing. Another thing I wanted to note that I noticed doing timestamps is that at one point, Wendi is talking about her parents and she says they're super happy in love. I just thought that was fucking funny. And then let's see. Okay. And then the other thing, so Jeff Lacasse, so Wendy's ex-boyfriend, that interview. So I want to make a note about that. So I really want to cover that interview. But one thing I will note is that footage, which is like 2.5 hours long or something like that. Oh, there's only one channel on YouTube that has that footage, like the raw footage. And some people have borrowed, snippets of it or whatever, or just commented on it without showing it. But they're the only channel that has it. So I have actually reached out to that creator. Shout out to Super Planner Girl. I've actually emailed them. Haven't heard back yet, last I checked, but I have emailed them and asked their permission if we can use it and told them I'll give them the credit. I'll, put a link to their channel and all that. Right. So, and it may or may not, right? Sometimes, the copyright thing, there's, people can have it where YouTube automatically does it, or it could just be the type of thing where if the creator sees that you used it, they do it manually, right? But either way, if I get permission from the creator, should solve that problem. So hopefully that will work out and we can do that. So the other thing I wanted to mention is got a couple things here. So first of all, this. So this is the thumbnail. It's not quite finished yet, but here's what I got so far. So this is for a Squirrely New Year's Eve. And as you can see, it's going to be nuts, it says. And look, I even found this nut tree, party nuts for the squinguin. So featuring MTV The Real World True Crime Edition. Big shout out to Heather for giving us that idea last night. So we're going to talk more about that tonight as well. And if you can tell, this is the actual logo. And then if you guys recall, sometimes they put The Real World in this type of font. So I put the True Crime Edition. I found like almost the exact font and put that there. And they always do it in yellow. So I added that part on, but this is the actual logo. And then also the Best of Glenn premiere. And then the and more is that I'm thinking, hopefully, if I hear back from that creator by then, the and more potentially could be, doesn't have to be, could be the Jeffrey Lacasse interview, or it could be other things. But at the very least, we're going to do the MTV Real World True Crime Edition and the Best of Glenn premiere, and I'm sure there will be other squirrely things in store. Yes. So are you familiar with that show, The Real World? It's basically just a bunch of people living in a house and, you know, sleeping with each other and fighting and, you know, doing that type of thing. But this was an idea from Heather. So this was at the end of the live stream last night. We were joking about what would it be like if we did if there was an MTV Real World edition where it was like different, you know, people from these different cases and they're all living in one house. And so, so that I took that idea and ran with it. So let me show you what I have here. And we're going to work on this a little bit tonight as well. So this is the document. So we're going to work on the prelim stuff here, right? So the parameters, and we're going to talk about what the parameters could be, and we will go through it. And then the prelims. So you guys let me know if you like something else. I put guys and girls. I didn't know if men, women, or male, female, or dudes, and I mean ladies, you know, there's all kinds of words, right? So we can change these up, but for right now I just have guys and girls. So this would be like, and we're going to talk about this as we go through it, like the preliminary, but the idea would be that hopefully on New Year's Eve, we can have like the finals and y'all can vote on who would you like to see in the house, the Real World, MTV Real World, True Crime Edition house. Who would you like to see? And we're going to figure out how to narrow that list down. So this is what I've got here for this. So we're going to work on this as well a little bit tonight in preparation for that. And as for the streams between now and New Year's Eve, it's kind of up in the air because I'm waiting to hear back from a number of students because of the holiday and everything, and get them locked down with the schedule. I've got people in different time zones. So like, for example, I think I moved a number of things to Tuesday, but that won't be the case. There will definitely be something tomorrow. I just don't know yet what it will be and when, but hopefully I'll hear from these people tonight or tomorrow morning. And, you know, I've got Casey Anthony, and then I've got a Murdoch stream. So those will definitely happen. It's just a matter of when. So, you know, y'all can check in the Discord. And of course, you know, it's always going to be on YouTube. So yeah, so just, unfortunately, I just don't have those times locked down because of my lessons, but I will have that done as soon as I hear back from people. Because luckily my students don't want to miss their lessons even when it's the holidays. Why does this font? Okay, now that looks like it's the same color. Okay, so that's that. So what do you guys think of the thumbnail? Oh, you're preaching. Is that your first time? That's a big deal though. We will probably be going late night squirreling, right? You know, for those of you guys who want to spend your New Year's Eve into New Year with us. No pressure, but I will be here. So I'll have the stream for whoever can make it. I figure there's probably going to be some people that, you know, don't have anything going on, or maybe they have something the next day, or they can finish up with something. Of course, we also have squirrels in different time zones. So we will just be doing our squirrel thing. Second time. Well, awesome. I didn't even know there were sermons on New Year's Eve, but that's pretty cool. That's pretty cool. So yeah, Tuesday night, that's New Year's Eve. Right. Yes, I'm just thinking in my brain. So that's what we got going on right now. We'll have this and more. Got lots of fireworks and everything. Got the party nuts. Y'all can bring your snacks, whether it be nuts or something else. You can bring your champagne or whatever you want to drink, and we'll have a little party. What do you watch? Do you watch the ball drop or? Interesting. So you preach through Zoom, I guess? And I felt like, why in my brain do I feel like there was another note I needed to make about something else? I can't recall that right at this moment. I mentioned the Jeff Lacasse interview. That'd be awesome if we can do that. I think that's all my notes. I also put some links, if you guys haven't seen them, in the Discord related to the Adelsons. That are really good. There's like a Laura, you know, where he has Joel on, and just to note that video is from like, I think 3 weeks ago. So it's before the big news about Wendi, but it's interesting because they do talk about that. They do talk about a lot of the things that we've talked about. They go through the background of the case, but also they get into more detail regarding the lawyer shenanigans with the conflict of interest. And there's some funny things too there that Joel mentions about Wendi. And he also references too how he knows like every single person in the family and all their friends, which I had also noted. So there's some funny things. And there's also a clip from Wendi testifying at Charlie's trial, and they talk about her book, among other things. Oh, okay. Well, cool. So you'll preach at 12 a.m., I guess. But that is neat. So, but we will definitely talk more about these other fun things. But for now, let's go ahead and jump on into the whole thing that we are here for. So the goal, we'll see how we do. The goal is to make it through 8 of these. We'll see how we do. Again, like some of them are longer than others. I want to also note that in Bryan Kohberger, the defense in that case had filed 13 motions related to the death penalty. And here, not that it's a contest, but if it were, Jose Baez wins by 1 because there's 14 total motions related to the death penalty. And interesting to note is that in Mario's case, even though he's, was charged earlier, and so as far as all the filings and the pretrial litigation, he's been months and months ahead, right, in terms of, the timetable. What's interesting is in his case, so far, they've only filed 4 motions, and it's exactly the same 4 as 4 of the ones we have up here related to victim impact evidence. That's all they've got for his case, because I was going to go over those as well, but that, like I said, it's exactly the same as 4 of the ones we will already talk about. So what I'll probably do is I'm assuming there's going to be more. What I'll probably do is they may be pretty much the same for the vast majority because the charges are identical between the two. But if there's anything that is different, I will definitely cover those as well, of course. So, okay. So yeah, so if you're still finishing up around midnight and then you wrap everything up there and you feel so inclined, I'm sure we will still be going without a doubt. So, but that's awesome that you're having that opportunity. I'm sure you will do great. So first up, we have this, and these, a lot of these were filed on the same day. So the first 4 were all filed on November 6th. And then the next set of 4 were all filed on November 15th. So, okay. All righty. All right. So first up, we have defendant's motion to declare prior violent felony language unconstitutional for vagueness. Now, for anyone who's followed the Bryan Kohberger coverage, the vagueness we heard a lot about that in that case as well. It's interesting, right? Because these are different states. So that's what I think is, there's going to be some similarities. There's going to be some differences. But I was already surprised right off the bat that the vagueness was also a similar grounds for this motion. Because that could have just been an Idaho thing. So here we go. I'm not going to worry about reading, this entire first paragraph. So, okay. In support of this motion, Ms. Gardner would show 1, the defendant is charged by indictment with first-degree murder and other non-capital offenses. 2, on November 3rd, 2023, the state filed its notice pursuant to sections. Can I make this look different so you guys can see it better? Let me just see here if there's a way I can make it look more obvious, like visually. Gosh darn it. Let's see here. Customize toolbar. That's not going to help. What does this do? Oh my God. This is how we got to the AI the other day. I don't know what. Oh, that's, I think, signature. Fill in. Oh, draw freehand. I don't really want to highlight it all. Well, anyway, comments. I double click it, nothing happens. Okay, well, anyway, just because, I always try to highlight as I'm reading, but I don't know if that's not the easiest to see. But anyway, the cursor is there. Okay, so on November 3rd, 2023, the state filed its notice pursuant to these sections, Florida statutes, indicating that it intends to prove and has reason to believe it can prove beyond a reasonable doubt 3 statutory aggravating factors, including the aggravating factor found at blah, blah, Florida statutes. The defendant was previously convicted. Okay. So this is very similar to one. Now, what's funny is up here at the top, right? It says vagueness, right? And again, that was one of the motions in Koberger. However, the basis was different. The base for this one, however, was similar, if not identical, to a separate Koberger motion, which was the future dangerousness aggravator, which was like saying, like what we're seeing here, right? This aggravating factor is known as the prior violent felony aggravating factor, because it's essentially, it's like saying that because they've been charged with this crime, that's a prior, because remember, like another similarity too, right? Between Shanna Gardner, if she's convicted, and Brian Koberger, if he's convicted, they both have no felonies on, they have clean records, right? Going into their trials if they're convicted. So it's like, circular reasoning type thing. So that's interesting, but it's interesting that this is in the vagueness motion. So, okay, prior violent felony. All right. So 3, during a capital penalty phase, the jury must unanimously find at least one aggravating factor be proven beyond a reasonable doubt in order to consider the imposition of a sentence of death. Though it's clear that a prior conviction of a capital felony constitutes this aggravating factor, the statute does not articulate any specific crimes criminalized under the Florida statutes that constitute a felony involving the use of or threat of violence to the person, or give any definition for such a felony. And there's a footnote here. Defendant recognizes that the term forcible felony is better defined by the Florida statutes and includes a non-inclusive list of forcible felonies. However, the legislature did not use this common statutory language in its definition of the prior violent felony aggravating factor. Okay. 5, Florida courts have stated that it is a matter of law to be decided by the courts as to whether a criminal offense constitutes a felony involving use or threat of violence to the person. Such jurisprudence is seemingly clearly unconstitutional in light of a litany of Supreme Court of the United States cases, including Erlinger, and I think they may have cited that as well for Koberger. The Supreme Court of Florida has held that a felony involving the use or threat of violence to the person is limited to those convictions in which the judgment of the conviction discloses that it involved violence. More recently, this is number 7, the Florida Supreme Court has held that whether a crime constitutes a prior violent felony is determined by the surrounding facts and circumstances of the prior crime. Florida courts have also limited the aggravating factor to only a felony involving the use or threat of violence to the person, to only those life-threatening crimes in which the perpetrator comes in direct contact with the human victim. Number 8, the 5th and 14th Amendments to the United States Constitution each contain a due process clause. Section 1 provides, nor shall any state deprive any person of life, liberty, or property without due process of law. The Supreme Court of the United States has interpreted the due process clauses in the 5th and 14th Amendments identically. And this is all backing up this, right, with case law. So these are subsections here with more case law. Okay, here we go, though. In Johnson v. United States, the Supreme Court of the United States declared that the residual clause in the Armed Career Criminal Statute was void for vagueness under the 5th Amendment's due process clause. The ACCA contained a statutory definition for the term that included burglary, arson, or extortion involves use of explosives or otherwise involves conduct that presents a serious potential risk of physical injury to another. The italicized portion came to be known as the statute's residual clause or catch-all provision. It was the residual clause that is strikingly similar to the prior violent felony language that the court declared to be void for vagueness. That's in bold there. Oh, that is really interesting. I bet you're going to catch everybody by surprise by reading a trial transcript, but you know what? I wouldn't expect anything different from you, Flash. That is awesome. That is awesome. Good for you. Good for you. On YouTube. Oh, okay. So we will be able to watch this. Is that what I'm hearing from you here? The court in Johnson explained that the government violates the due process clause's guarantee by taking away someone's life, liberty, or property under criminal law so vague that it fails to give ordinary people fair notice of the conduct it punishes, or so standardless that it invites arbitrary enforcement. Now, arbitrary, we heard a lot as well when it came to the Brian Koberger death penalty motions. I think they used it. I also used it a lot as well, especially in regards to the hack aggravator and the utter disregard aggravators. You guys know how I feel about those. The court continued, the prohibition of vagueness in criminal statutes is an essential of due process required by both ordinary notions of fair play and settled rules of law. The void for vagueness doctrine, as identified by the court, guarantees that ordinary people have fair notice of the conduct a statute prescribes. Papa Cristo. And the doctrine guards against arbitrary or discriminatory law enforcement by insisting that a statute provides standards to govern the actions of police officers, prosecutors, juries, and judges. The reason for void for vagueness doctrine, as explained in the recent decision in Sessions v. DiMaia, invalidating the residual clause of the definition of a crime of violence, and that's from the United States Code, Section 16, for use in the Immigration and Nationality Act, stems from the separation of powers, which requires the legislature rather than the executive or judicial branch to define what conduct is sanctionable and what conduct is not. Now, that matters for a lot of things. We've talked a lot about this, again, as it pertains to Koberger, not in regards to the death penalty motions, but in regards to the IgG and the DNA, right? About how case law is law, but it's not a law from the legislature, right? It's so, in other words, that's coming from the judicial branch, right? Case law versus rules or statutes that are written or codified by the legislative branch. So completely different, right? And so oftentimes case law might be kind of filling in the gaps unless and until there is something, in the legislature that for example, like again, with the IgG, the DNA, but there's a million other examples. So this is really interesting to me because this is referencing the same type of idea here, right? Separation of powers requires the legislature rather than the executive or judicial branch to define what conduct is sanctionable and what is not. So what they're saying here is case law, according to this, cannot be what you use in order to determine what conduct is sanctionable and what is not. It has to come from the legislature, i.e. a statute, okay? And then here's a quote, and this is from the U.S. Supreme Court, case law, Colander v. Lawson. If the legislature could set a net large enough to catch all possible offenders and leave it to the courts to step inside and say who could be rightfully detained, it would substitute the judicial for the legislative department. Yeah, I agree. A statute or ordinance is void for vagueness when, because of its imprecision, it fails to give adequate notice of what conduct is prohibited. Thus, it invites arbitrary and discriminatory enforcement. A mark of a vague statute includes differences in interpretation amongst judges that invite appeals. As a result of varying interpretations by trial courts of this section's vague language, the Supreme Court of Florida has often been called upon to decide what offenses are and are not prior violent felonies in the context of an aggravating factor to support the imposition of the death penalty. So now we're getting really into more of the heart of this, right? Because again, prior violent felonies, what does that sound like to you guys? Does that sound like something that should have happened before the crime in question? And again, this would be in the penalty phase. So at this point, they have been convicted, but I would not consider that prior, right? Like, let's say, because in Florida, they do things lickety split, right? In Idaho, they take some time, but I wouldn't be surprised if it's like you get convicted and then sentencing starts immediately. Like I've seen that in some cases in other states where they just jump right on in. I believe they did that in Chad Daybell's case, but that's not typical, but I have seen that in other states. And it's like, oh, so because it happened 10 seconds ago, it's a prior violent felony. Like that's not how I interpret that. Please give him, yes, British accent. We request the British accent. Jolly Jane. Yeah, right. Well, you got to do the hearies. You got to do the hearies. I mean, I know that would be the bailiff and not the judge, but just to give your viewing audience who's not familiar with trials, give them a flavor of what is still going on to this day in the Massachusetts courts, minus the red solo cups. Okay, so a mark of a vague statute includes differences in interpretation amongst judges that invite appeals. As a result of varying interpretations by trial courts of section blah, blah, vague language, the Supreme Court of Florida has often been called upon to decide what offenses are and are not prior. Oh, I think I already read this part, but yeah, in the context of an aggravating factor to support the imposition of the death penalty. And these are examples of where they found that the trial court erred for different times where they said it was a prior violent felony and it was decided that it was not. If trained, educated, and experienced members of the judiciary cannot uniformly agree on which felonies involve the use or threat of violence to the person, it cannot be said that ordinary people have fair notice of the conduct sanctionable as an aggravating factor, making him or her eligible for a sentence of death. So what this sounds like to me so far is that the courts have determined in Florida, at least, that if it was the crime that happened, let's just again, for the sake of example, let's say you're convicted and then that same day you start the penalty phase, right? Apparently that's not the argument that doesn't count as prior, but instead, well, maybe there's going to be a second part to this and that's what they will say. But for right now, what we're hearing is that their problem here that they have with it is more that it's vague because there's a disagreement over what counts as the use of threat or violence to the person. This right here is the thing that's in question as far as it pertains to the vagueness here, right? Moreover, it is clear that the Supreme Court of Florida is defining what conduct is sanctionable and what it's not. Right. And like it just said earlier, right, that they can't do that. That has to come from the legislature. Another mark of vagueness in the statute, because the statute is standardless, the Supreme Court of Florida has provided its own definition of a felony involving use of threat or threat of violence to the person. The Supreme Court of Florida now seemingly requires that the underlying crime be life-threatening crimes in which the perpetrator comes in direct contact with the human victim, and that while certain crimes are not per se a prior violent felony, evidence and or testimony may be introduced to satisfy the requirements of the aggravating factor. Yeah, that sounds a little bit weaselly to me. Of paramount significance, it is abundantly apparent that it is the judiciary on appeal rather than the legislature that is determining what felony convictions are sanctionable as a felony involving the use or threat of violence to the person. For purposes of establishing eligibility for a death sentence, the courts are deciding who has a prior conviction of a felony involving the use of or threat of violence to the person, and not the legislature, permitting the courts to determine the applicability of an aggravating factor on a case-by-case basis is, as a matter of law, is ripe for arbitrary and discriminatory enforcement. Creating law is not the role of the judiciary, like we just talked about, right? And talked about before in other things, like, again, the Koberger with the IG, right? They don't create the law. That's the legislature, and violates the separation of powers. And that's why case law is case law. It's kind of like a gray area, right? Because it's not a law, but it's what you have to follow, right? In Flash, we can practice your British accent here. Repeat after me. My name is Flash. I can't do it on command. Sorry. Okay, let me keep reading. Moreover, having the judiciary determine whether or not a defendant is eligible for a death sentence by virtue of a prior violent felony conviction violates the oh wait, there was a footnote here. Where did that come from? Oh, okay, right here. So this is from case law. I think we did read that part. Right. Requirements of the aggravating factor. It should be noted that such an analysis directly conflicts with the standard criminal jury instructions in capital cases, which adopts a categorical approach to determining whether a crime is a felony involving. And by the way, we're going to go through this at some point when it's relevant. We will go through the standard criminal jury instructions for death penalty cases in Florida. The crime of previous crime is a felony involving. Okay, interesting. Okay, so yeah. So moreover, having blah, we read that conviction violates the Sixth Amendment and the holdings of Ring v. Arizona and Hearst v. Florida. So this is Supreme Court case law, and this is this is a federal case that's appellate, citing federal appellate courts there, which make clear that a jury, not a judge, must find all facts necessary to impose a death sentence. Like the statutes that issue in Johnson and DiMaia, a portion of section blah, blah, passes constitutional muster. That is a conviction of another capital felony. However, the remainder of the section is akin to the residual clauses that issue in Johnson and DiMaia and is void for vagueness. Moreover, even modifying the instructions to conform with case law to have the jury determine whether a prior felony conviction involved in the use or threat of violence to another person does not resolve the vagueness challenge because it lends itself to the unguided discretion of a jury. The statute, because it is so broad and so vague, also fails to genuinely narrow the class of persons eligible for a death sentence. And those of you guys who followed the Koberger coverage might be like, the narrowing. And don't worry, we will have a motion related specifically to the narrowing. There it is, as well here. So referencing to the narrowing here as well. The narrowing the class. Again, another similarity. I would imagine probably in every state that has a death penalty, we will see that. Florida courts have also increased the gravity of the danger of the vagueness and overbreadth of this aggravating factor by permitting contemporaneous convictions to serve as the underlying conviction for purposes of this aggravating factor. Contemporaneous convictions, so convictions that happen at the same time. So now maybe I wonder again, are they going to be getting into the thing that I'm like, hey, prior conviction, this doesn't count as prior to me. And so maybe we're getting there with starting out with contemporaneous, right? And this is a holding that contemporaneous conviction cannot be used to support this aggravating factor. Similar statutes enacted by other states do not suffer from the same constitutional infirmities. Like it's sick. Florida's sick, you guys. Cough, cough. Georgia's capital sentencing scheme requires prior convictions to be for a capital offense, or I'm not going to read all these. The statute contains no residual clause. Arizona's capital sentencing scheme uses the term serious offense, but statutorily defines them to be 13 specific crimes. Alabama's analogous provision applies only to prior convictions for murder in the 20 years preceding the crime. The statute also defines the specific offenses that constitute murder for purposes of the provision. California's similar provision is limited to prior convictions for murder in the first or second degree. Okay, I'm not going to go through the rest of these. That are just other examples. Death is a unique punishment in its finality and in its total rejection of the possibility of rehabilitation. For that reason, the Supreme Court of the United States has made clear that the Eighth Amendment demands heightened reliability in any sentence of death. Accordingly, heightened standards of due process apply. We know that. The Supreme Court of Florida has referred to capital cases as having the ultimate stakes for the defendant. With the ultimate stakes on the table for Ms. Gardner and the requirement that this honorable court be particularly sensitive that every safeguard and due process right afforded is observed, this honorable court should find that the language, a felony involving the use or threat of violence of the person, is void for vagueness because it does not provide fair notice of the conduct prescribed by the statute and permits arbitrary or discriminatory enforcement. To hold otherwise permits the imposition of the most severe penalty under the law upon individuals without specifying the conduct that triggers eligibility for that penalty, a concept rooted in the twin constitutional pillars of due process and separation of powers. I have to say this is really, 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 really well written. It's very easy to follow. I mean, if you're familiar with, how this, familiar with these things, right? But I find it in a lot of ways, I think more, well, I don't want to say anything against Brian Koberger's defense team because I think they are phenomenal, as you guys well know. But this writing is very, I think, even a couple notches of how to say this. I think it's better writing. And I think that they are laying this out really linearly and clearly. And their argument is being represented in the best way possible. So, right, they were more British. Well, and they still are pretty British. I mean, even the layout and everything, the way that, we all learned that from Karen Reed. But that's funny. In the year of our Lord, wow. Can you do that though? You should do that. Just pretend you're in 1901 when you read that for your congregation there. You just go back in time and keep everything. That would be amazing. That would be amazing. Okay, Ms. Gardner recognizes that the Florida Supreme Court has rejected challenges to this aggravating factor based on vagueness and overbreadth, but argues that the court. So what this is saying is that prior, right, the Florida Supreme Court has rejected similar arguments, right, but argues that the court should depart from those decisions in light of the recent United States Supreme Court cases cited here. And so what they're saying is now, Judge Kite, there's new case law, U.S. Supreme Court case law, mandatory binding authority, that are recent, right, that hadn't happened yet. So now, because of that, you should depart from those previous decisions because they did not have the benefit of this recent case law. So it looks like this is actually written by Mr. Carodi. Okay, and then these are the attachments here. We're not going to read all these because, again, we will go through all this with the jury instructions later on. Okay, so now we are on to the next one. Actually, let me exit out so I know. Okay. Number 2, guys, number 2. Motion to declare Florida statutes unconstitutional. By the way, whenever we see this, we're going to see this a million times. This would be, I'm sure, the capital punishment under the Florida statutes. That's what that is referencing here. So that's funny. They have here the CCP, which just reminds me, I wonder if that's like hack, right, in Idaho. I'm sure we will learn more about it, but just again, thinking like 3 letters that are abbreviating for something else. So procedural history. Oh, did I even read what this is? Right, yeah, declaring it unconstitutional. Okay. State's notice believes that it can establish that the aggravating factor codified at, again, here, that the capital felony was a homicide and was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Okay, it's like the hack. It is like the hack. I figured, here we go, guys. I'm going to get mad. I don't want to get mad, but I'm just going to make me mad. The current standard jury instruction for the CCP aggravating factor is that the first degree murder was committed in a cold, calculated, and premeditated manner. So there it is, CCP. Cold means the murder was the product of calm and cool reflection, like a swimming pool. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs. Okay, well, you can already see the problem here, right? Because of the redundancy. I mean, I'm already seeing that. Because calculated, look how they try to weasel their way around it by saying prearranged design. How is that not the same as premeditated, though? Like, literally how? This is just so much. This reminds me so much of like the hack aggravator and the utter disregard aggravator that it's like, come on. Are you guys literally unable to read? Like, by you guys, I mean whoever decided that this was okay. Because clearly prearranged and premeditated. All right. The killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of and the premeditated intent. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. If I weren't still getting over my sickness, I would burst into song here with Reflection from Mulan, but we'll have to save that for another day. However, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. Law and there's the vagueness again. Void for vagueness. Justice Felix Frankfurter from 1945. And again, just like we saw with Cobra, a lot of this is going to be very similar, especially when it starts out with these constitutional rights, due process, things of that nature. And again, some of the same case law. So we're not going to read it when we've already read it, right? But a lot of this is going to be some of the same things here because it will be the bases for a lot of these motions, rightfully so. Arbitrary again, void for vagueness. And you can see here, just like we saw in Koberger, when a lot of this is based on the same type of things, then, it's typical that one can see how either if they deny one, they will deny them all, at least within a batch where they're using a lot of the same, grounds, if you will, for these motions, and these are oftentimes, right, denied. But again, like so far in the first one, as we saw, he said, hey, new case law, you can depart from what your previous, other, predecessors have done. So, this is all the same. void for vagueness again. But the thing I have to say is this, right? Like, they're not wrong, because it's true that, you know, the one about the prior felony in terms of the languaging that, you know, that was necessary there was vague, but so is this. They're both vague. So, I mean, you know, it's accurate, right? The CCC or the CCP vague. Okay. Accordingly, the court tried to save the constitutionality of the aggravating factor by holding that a jury instruction must be given. This is exactly what we saw with Idaho with the hack. This is exactly what we saw, that they have to have a jury instruction. This is identical, but just swap the 3 letters. It must be given to explain the statutory language of the CCP aggravating factor anytime the state pursued proving it. As explained, supra, the judiciary cannot define what conduct is sanctionable as CCP and what is not, nor can a jury instruction save an otherwise vague statutory sentencing enhancement. Therefore, the Supreme Court of Florida's efforts to salvage the CCP aggravating factor through expanded instructions cannot make an otherwise facially unconstitutional statute constitutional. So that, again, this is that same statute, right? Fails to adequately inform the sentencer what it must find to now reach a binding finding necessary for the imposition of the death penalty. Because the statute itself is constitutionally vague, this court has an obligation to strike the aggravating factor as void for vagueness. Notwithstanding the Supreme Court of Florida's finding that the CCP aggravating factor was constitutionally vague and the clear inability of a jury instruction to resolve constitutional issues, another mark of a vague statute includes differences in interpretation amongst judges in the application of the statute that invites appeals. So now they're going to go through all the times. So like Judge Kite, look at all the times where this was an issue when it came to appeals. The Supreme Court of Florida has often been called upon to decide what conduct qualifies and does not qualify in the context of the CCP aggravating factor to support the imposition of the death penalty. The CCP aggravating factor was enacted by the legislature in 1979, and close to 40 years later, and again, we know that right, because they're referencing the statute. That's how we know it's from the legislature. And close to 40 years later, and dozens of appellate decisions, trial courts still don't know how to apply for it. Or sorry, how to apply it. For example, blah, 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 blah. Supporting case law. It was a spontaneous murder, so therefore there wasn't heightened premeditation. More supporting case law here. The Supreme Court of Florida's jurisprudence on the CCP aggravating factor is filled with meaningless distinctions as the appellate court, rather than the sentencer, determines who dies and who receives mercy based. And they mentioned, again, something similar in the last one, right? Where it ends up being left up to the appellate courts, and that's unconstitutional. They will probably say that again here. This beyond the Supreme Court of Florida's proportionality review in death cases, case law is riddled with nuanced factual recitations that have to be read and reread to gain even a confused understanding of when the CCP aggravating factor applies and when it doesn't. The frequent findings of error in applying the CCP aggravating factor under Florida's Prearranged capital sentencing scheme by trial judges who have legal training. The assistant of court attorneys, I see where they're going here. They're going to say, how do you expect a jury then to figure it out if all these other people can't, right? Judges, court attorneys, and weeks between a jury recommendation, Spencer hearing, and ultimately the sentencing hearing demonstrates the constitutional infirmity of the CCP aggravating factor. Here it is. If trial judges cannot make findings that withstand appeal regarding the CCP aggravating factor, there is no reasonable basis to believe that a jury, likely composed of members who lack legal training and which has no ability to conduct legal research, can properly interpret the statute and its vague instructions. Yep. Which merely provides synonyms for each of the terms in the statute. Right. Like I already pointed out earlier. And then apply them as the law in scare quotes to the evidence of the case. Given that Florida law makes clear now that it is the jury, not the judge, that must make the findings necessary for eligibility and imposition of a death sentence, the danger of using, so that's a good point, right? Because it used to be that it was up to the judge, and that has since changed where now it's the jury. So that is a good point, right? Because you're talking about interpreting law amongst lay people versus a judge. Shouldn't be vague either way, in my opinion, right? But it's even more dangerous when you're putting it before a jury. The danger, speaking of using a vague statute constitutes an even more diverse attack on a capital defendant's due process rights. Yep. Moreover, the weighing of a single invalid aggravating factor violates the Eighth Amendment. Capital defendants, okay, this is again the same. They've been citing the same cases here. Genuinely fails to narrow the class. Because the death penalty was only imposed on a capriciously selected random handful, please no. Please tell me that is not correct. It was cruel. That makes me sick to my stomach. It was cruel and unusual in the same way that being struck by lightning is cruel and unusual. You've got to be kidding me. Is that really what used to happen? I can't. And the Eighth Amendment to the United States Constitution does not permit this unique penalty to be so wantonly and freakishly imposed. Right, the worst of crimes. I've vented about this a whole lot when I went over the Kohberger documents, because this is just so subjective and it just drives me crazy. But this is, again, pointing to the narrowing. The worst of the worst, right? The most pitiless slayer and whatnot. We saw that language with Kohberger. Well, I say Kohberger. That would have been referenced in any of the Idaho death penalty motions for any criminal defendant. But, it's just. So so in Florida, the aggravating circumstances that they now use became part here of the legislation for the death penalty in 1972. Please tell me they've updated them since, for the love of God. Although I highly doubt it, because we all know how slowly that goes. The United States Supreme Court, while affirming that the central teaching of Furman, that the death penalty cannot be inflicted in an arbitrary and capricious manner, upheld many of those new capital sentencing schemes. The court concluded that the aggravating circumstances and other limitations in the statutes, like Florida's new statute, would suitably direct and limit the sentencer's discretion so as to minimize the risk of wholly and arbitrary and capricious action. And this is the heart of the issue right here. But again, we're going to see, it's interesting, right? Because again, there's a whole other motion dedicated to the narrowing, and a lot of this might be redundant. But if a state has determined that death should be an available penalty for certain crimes, then it must administer that penalty in a way that can rationally distinguish between those individuals for whom death is an appropriate sanction and those for whom it is not. That right there is exactly the heart of the issue as it pertains to the narrowing. And this is citing some of the same case law I already did. So they can do it in one of two ways. The legislature may itself narrow the definition of capital offenses at the guilt phase. For example, by narrowly defining the offense of first-degree murder and then making, so New York State is a good example, right? New York State is a good example because for first-degree murder, right, what you need, the elements that you need for that are akin very much to some of the things that you would see for capital, like in states that have the death penalty, right? They'd be like aggravating factors, very similar. Or you could also think of them as like enhancements. So that's why, as we've talked about, I'm sure we have, why it was difficult for them. Well, initially Luigi Mangione was charged with second degree, and then it was after they decided they could add in the terrorism that they could bump it up to first degree, because that's one of the elements. And yeah, we've covered that. I remember going through that. So yes. So at the guilt phase, right? So even though New York State doesn't have the death penalty, that's just a good example of how they do narrow first degree murder, right? In terms of in the guilt phase. Right. Like, yeah, narrowly defining the offense of first degree murder and then making every defendant convicted of that offense eligible for the death penalty. Again, that's not the case. You know, if you remove death penalty, then you can see how that pertains to New York State. But of course, then you could also say the same thing for states that have the death penalty. The same could apply. Alternatively, the legislature may more broadly define capital offenses and provide for a narrowing by jury findings of aggravating circumstances at the penalty phase. And that's what we have in Idaho, and that's what we have in Florida. A state is free to choose either of these options, but the Constitution forbids the legislature from dispensing with statutory narrowing altogether. So it's saying, states, you guys have two options. You can either narrow it at the guilt phase, or you can narrow it at the sentencing phase by using aggravating circumstances. Indeed, the narrowing principle is so fundamental to the constitutional administration of the death penalty that even Justice Scalia, otherwise a vocal critic of the court's Eighth Amendment jurisprudence, adhered to the precedent establishing that when a state adopts capital punishment for a given crime, but does not make it mandatory, the state must establish in advance and convey to the sentencer a governing standard. A meaningful basis for distinguishing, the few cases in which the death penalty is imposed from the cases in which it is not. Far from providing a narrowing effect, the CCP aggravating factor has a scattergun effect on persons against whom the state seeks the death penalty. It achieves no narrowing effect, but has become a catch-all aggravating factor that can be applied to virtually every first-degree murder. I agree with that entirely. Just like same thing with the hack in Idaho. Yep. I mean, especially because first-degree murder means it's premeditated that's like one of the distinguishing factors. And guess what the C and the P are of the CCP? Well, you've got cold, so whatever. And then you've got calculated, and then you've got premeditated, right? So redundant. Yeah, right. The Jackson court noted that one of the principal problems with the CCP aggravating factor statutory language was that without the benefit of an explanation of that some heightened form of premeditation is required, a jury may automatically characterize every premeditated murder as involving the CCP aggravator. Yeah, absolutely. The Supreme Court of Florida itself has said that a jury may, based on the statute enacted by Florida legislature, characterize every first-degree murder as involving the CCP aggravator. Literally, I mean, it's a no-brainer. When you look at what it is, it's like, yeah, that literally, yeah. Since only first-degree murder is punishable by the death penalty in the state of Florida, and the Supreme Court of Florida has admitted that the statute accomplishes no narrowing function, that is, by itself, it provides no principled way for a jury to determine the narrow class of first-degree murders for which the death penalty should be imposed from the many in which it should not. This court should find that it fails to genuinely narrow the class. Okay. The application of the statute, we'll just call it that, is inconsistent, arbitrary, and capricious. The uniqueness of the death penalty demands guided procedures that ensure reliability and consistency. The United States Supreme Court has recognized that death is different in kind, yada, yada. We've read that. Moreover, when a defendant's life is at stake, the court must be particularly sensitive to ensure that every safeguard is observed. Yes, yes. For close to 40 years, the Supreme Court of Florida has tinkered with the CCP aggravating factor, trying to define its terms, limit its application, and channel the discretion, of the sentencer. These efforts have highlighted the inconsistent, arbitrary, and capricious application of the CCP aggravating factor. The clearest example of this constitutional violation has been the court's erratic application of its own mandate for heightened premeditation. Again, this is just very linear, right? Because they just referenced the heightened. It's like, okay, so we know that they all have, like, first degree, right? They all have to have premeditation. So now for CCP, we need heightened premeditation. So like, what the fuck actually is that? Like, literally, what is that? Help, help, help. All right, let's see what the case law says. In McCrae v. State, the court struck the CCP aggravating factor finding made by the trial court where the defendant had stolen several boxes of guns from the victim's van and yelled, "This is for you, motherfucker." Wow. And shot the victim 3 times in the abdomen. Wow. Okay. So that's that is from that's Federal Court of Appeals, but Florida, from 1982. The court concluded that this was not a murder committed in cold, calculated, and premeditated manner without any pretense of moral or legal justification. So in other words, it would not have met the standard for CCP for this aggravator because it was not, it says. The court narrowly applied CCP, noting that it applies in which those murders which are characterized as executions or contract murders. Sorry, let me read that again. The court narrowly applied CCP, noting that the CCP aggravating circumstance ordinarily applies in those murders which are characterized as executions or contract murders, although that description is not intended to be all-inclusive. Now, why does that matter here? Contract murders, right? Relevant to this case. In Combs v. State, the defendant led the victim into the woods to rob her and her boyfriend of money and rugs. That's probably supposed to be drugs. I highly doubt that they went into the woods and brought some rugs with them and someone wanted to steal the rugs. I mean, I don't know. Maybe they were the fancy Persian type. That's wild. It's probably supposed to be drugs. Though the victim, there it is, drugs. Though the victim turned over the drugs and pleaded for her life, the defendant executed her by shooting her in the head 3 times. The court upheld the trial court's finding of the CCP aggravating factor given the execution style of the murder after the victim's pleas to live. Thus, in the first few years after it was enacted, the Supreme Court of Florida held the line, ensuring that the CCP aggravating factor was applied only to a very narrow group of first-degree murders. The standard started to slip in Herring v. State. In Herring, the court upheld the CCP aggravating factor where the defendant robbed a store and then fired a shot in response to what he believed was a threatening movement by the clerk, and then shot him a second time after the clerk had fallen to the floor. The majority relied on the second shot as evidence of heightened premeditation. What? That's insane. Justice Ehrlich, in his dissent, highlighted the constitutional problem created by the court's holding. So the dissenting judge, who likely was like, hey, what are you guys thinking? That's insane. The majority relies on the second shot fired after the clerk was on the floor as evidence of the heightened premeditation, but the record clearly shows the shot was fired within the same time frame as the first. And remember what we read earlier, there has to be like the time of reflection. And I made that joke about how if I wasn't sick, I would sing that song from Mulan about the reflection. See, then y'all would not, if I did that, y'all would never forget the part about the time to reflect, right? That would really bring it on home. Anyway, luckily we've got plenty of these motions and I'm sure it will come up again. And at that point, I'll certainly have my voice back. While I agree that more than enough time elapsed to follow from premeditation, I cannot agree that appellant had sufficient time for cold calculation. We have, since McCrae and Combs, gradually eroded the very significant distinction between simple premeditation and the heightened premeditation contemplated in the statute. Loss of that distinction would bring into question the constitutionality of the aggravating factor and perhaps the constitutionality as applied of Florida's death penalty statute. Justice Ehrlich's words were heeded by the court in Rogers v. State. And again, now they're addressing calculation, right? We conclude that calculation consists of a careful plan or a prearranged design. There's some more examples here. One would think that a decade would be sufficient for the Supreme Court of Florida to work out any kinks in the CCP aggravating factor. One would think, but that is not the case. By 1990, things were still unsettled. I love this. I love this. I love it when they go through the history. It's like, courts, get it together, man. In Vagueness v. State, the court rejected the state's argument that because Vagueness approached the victim after firing the first shot and then unjammed his gun 3 times before firing the fatal shots to the back of the victim's head, afforded him time to contemplate his actions, thereby establishing heightened premeditation. So because that was long, I'll just say the court rejected that argument, okay? The court wrote that because he had to unjam his gun, it was not evidence of heightened premeditation. Since reloading and unjamming both involve making the firearm ready to fire additional rounds, it's hard to discern any appreciable difference in the court's ruling. These nuances are typical of the confused and tormented case law on the CCP aggravating factor. The inconsistent, arbitrary, and capricious application of the CCP aggravating factor is not limited to the several cases cited above. So now, have some more case law, guys. Case law party. Case law party. Even more critical today, where a jury, not a judge, must make the critical findings necessary for the imposition of the death penalty, there must be clear, straightforward standards to guide the sentencer to distinguish the few first-degree murders upon which the death penalty should be imposed from the many upon which it should not be imposed. Couldn't agree more. The constitutional infirmities of the CCP aggravating factor cannot be resolved by jury instruction, and this court should find the CCP aggravating factor is unconstitutional vagueness for failing to genuinely narrow the class and for resulting in the inconsistent, arbitrary, and capricious imposition of the death penalty. They could make their own saying for this one too. IAC, inconsistent, arbitrary, and capricious. Wherefore, all righty, there you have it. Next up, let me X out of that. All right. Failure to allege elements that enhance punishment in indictment. Okay, take a sip. My coffee. So it's saying here that they needed to note the enhancements in the indictment. I mean, well, more than likely, what we've read so far, these typically don't go very far, just because, again, the courts are likely to, or, these trial courts are likely to, they don't want to ruffle any feathers. They don't want to make any waves. They're just going to be like, denied, because that's what usually happens, which is a shame in my opinion. But of the ones so far, I think this is the least likely to gain any traction, because basically what I think it's going to be saying is that when they initially indicted her, they needed to mention all the death penalty aggravating factors. And, as we know, those always come after the fact, right? Because the initial indictment is not going to be everything. It's going to be just what they need for an indictment, right? And then as they go through the discovery and they build their case, then they can decide what aggravating factors, if they're going to seek capital punishment. But let's keep reading. Right. The indictment does not allege a single aggravating factor that would make her eligible for death. Right. In the indictment, right? As we know, in every state with death penalty, they file the death penalty, intent to seek the death penalty happens later. And they have a time limit. I believe it's 30 days after the indictment. Within 30 days after the initial indictment is when they have to file notice of intent to seek the death penalty. So again, you can see already with that, it's separate. All right. The Florida statutes provide that a defendant has been found guilty of first-degree murder is only eligible for a death sentence if the jury unanimously finds at least one statutory aggravating factor proven beyond a reasonable doubt. Same applies in Idaho for that. I don't really know how they're going to make this argument though. This is not. Let's see. There's Erlinger again. Justice Gorsuch. I don't know. I don't know that this one is even really going to make any type of sense. Because Ms. Gardner's indictment does not allege a statutory aggravating factor, the proven existence of which is required by Florida statutes for eligibility for the death penalty. I mean, clearly that's not actually the case, because that's not how it's done. It is constitutionally deficient to charge an offense for which a death sentence can be imposed. Yes. Ms. Gardner recognizes that similar arguments have been rejected by the Florida Supreme Court. And we saw this in one of the other filings, right? Where they said, we know this has been rejected before, but here, look, something's different. Let's see what they say here. Oh, it doesn't even. So in the other earlier one, I think it was the first motion we covered, right? It was like, but look, there's been new case law. So like new things. But that's not the case here. They're just, again, it's like they're just like, yep, we know that this has been rejected. There it is. There it is. Okay. Nothing else they can say about that one. All right. Next up. Now here is the failure to narrow in and of itself, right? But again, so a lot of this is definitely going to be redundant. I mean, based on what we've already read. So let's see here. Berman. A lot of the same language. Okay, here we go. So in 1987, the legislature enacted the first of a series of additions focused on the status of the victim. So law enforcement officer. Now, again, these are very similar to like in New York State, right? To get first degree at all. But in Florida, this is for death penalty, right? Elected official or appointed public official, person less than 12 years of age, and particularly vulnerable person. That one is not one of the enhancements in Florida for first degree. That's just here. These are now codified. In 1986, the legislature added that the felony was committed by a criminal street gang member. The legislature added if you're a sexual predator. The most recent one in 2010 was to include a person subject to an injunction who murders a protected person. So like, for example, like, let's just say like if you murder like a witness or something, maybe. As discussed above, the current statute enumerates 16 aggravating factors, twice the number as the initial Furman statute. They are. So here's the 16 aggravating factors. And actually, we've already covered these on a different live stream, so I'm not going to read them all again. But yeah, because I remember we covered it when we were talking about this particularly, the pecuniary game, but we read through all of them. Oh, and look, there's the hack. They have, I forgot they have the hack as well. Incredible. I just have to keep scrolling. Okay. And this one, I believe, was also cited in the Koberger motions for failure to nail the class. So Mr. Hidalgo showed that 98% of the first-degree murders in Maricopa County, Arizona, were eligible for the death penalty because of at least one aggravating factor was present in each murder. Yeah, so that doesn't sound like narrowing, right? This assertion went undisputed through the state courts. Importantly, the United States Supreme Court order denying the petition was accompanied by a 10-page statement by Justice Breyer, who was joined by Justices Ginsburg, Sotomayor, and Kagan. The justices rejected the Supreme Court of Arizona's logic defending its penalty scheme, which, like Florida's scheme, uses statutory aggravating factors. So does Idaho. The Supreme Court of Arizona found that the narrowing requirement was achieved by 1, Arizona's first-degree murder statute, 2, the identified aggravating circumstances, 3. So let me just articulate what they're saying here. So they're saying what we're going to go over here, right, with these numbers, this is what the Supreme Court of Arizona found to say that sufficient narrowing was achieved, right? But whatever they're about to say is in this, according to this motion, right, from the defense, they're saying that the Supreme Court disagreed with Arizona when Arizona said, here, look, we did it. We did the narrowing. All right. So 1, it was achieved by the first-degree murder statute. 2, the identified aggravating circumstances. Isn't that circular? I'm sure it's circular reasoning. Okay. 3, the fact that the state must prove 1 or more of the alleged aggravating circumstances beyond a reasonable doubt. And 4, the existence of mandatory appellate review. You've got to be kidding me. And 5, Arizona's statutory provisions applicable to individualized sentencing determinations through the consideration of mitigating circumstances. Gross. It's just gross. This is gross. The justices also rejected the assertion that prosecutors could perform the narrowing function. Despite rejecting the state court's logic, the justices provided that they simply wanted a record on appeal that had been further developed with empirical and expert evidence. Hidalgo wasn't the first time Justices Breyer and Ginsburg expressed concern that the death penalty was not being limited, quote, to those who commit a narrow category of the most serious crimes and whose extreme culpability makes them the most deserving of execution, end quote, and was being applied in an arbitrary manner. There's that word again. Oh, your iPad had died? Are you on your phone now? Yeah, make sure you charge your devices, people, so you don't miss any court filings. In Glossip, and actually Glossip, I do believe, was also cited in Koberger filings. Justice Breyer noted that studies showed the death penalty was not restricted to the worst of the worst, but was imposed arbitrarily based on, oh yes, I do remember, because then they got, at least in Koberger, right, they got into the whole history of the geography, and that was a whole trip down Idaho history with the geography. That's right. Let's see if they do that here as well. Probably not. Probably not. Death sentences, while declining in number, have become increasingly concentrated in an even smaller number of counties. Oh, never mind. Here we go with the counties. I spoke too soon, people. This is where we get into the geography. I'm not going to read all this, the geography thing. So this, I guess, looks like it is just kind of a standard outline of how you do this, right? Because, yeah, again, the similarities are really, there's a lot, right? Yep, Duval County. With 16 statutory aggravating factors that have proven make a defendant eligible for death sentence, Florida's prosecutors can capture in the capital net those whom the United States Supreme Court has called the average murderer, supposedly exempt from execution under constitutional law. This mindset is not limited to the defense bar or justices in Washington, D.C. At a legislative hearing in Tallahassee in 2016, a retired Florida judge testified that due to the aggravator creep in Florida's statute, quote, it is impossible to come up with a fact situation in your mind that amounts to a first-degree murder without at least one aggravating factor in Florida. I couldn't agree more. Shout out to retired Circuit Judge Eaton. In the case of Ms. Gardner, the state has not come up with just one aggravating factor. In the case of Ms. Gardner, the state has not come up with just one aggravating factor it believes it can prove based on theory of the case, but 3. With any single statutory aggravating factor if proven making Ms. Gardner eligible for death sentence, see state's notice of November 3rd. I guess that's when that was their notice of intent to seek the death penalty, which I believe we already covered. And then here's a memorandum. Again, about the narrowing. This is a lot of the same. This is the case law here. Yeah, this looks like this looks verbatim like what was already in the first pages of this, at least so far. Yeah, I think it's just fleshing out the case law that was already mentioned. Okay, so next one. So now we're on to the next category. So now we are here on November 15th. So just over I guess a month and a half ago. So now we are on to the victim impact evidence category of motions regarding the death penalty. And we talked a lot about this with Brian Koberger as well. And I wonder if we're going to see anything about trifurcation here. I mean, it'll be interesting. All right. Defendant's motion to exclude any and all victim impact evidence. And I hate to say it, I may have to save these because I can feel my voice going. This is why I didn't want to do these last night, because it's a lot of talking, right? It's a lot. It's just me reading. I don't know that I can make it through, and I would rather do them all together because I've got these with all the death penalty motions here. I've got them grouped into categories. So there's a set of 4 here that are all related to victim impact evidence. So I would rather do them all together in a group. So I think I will save those for part 2. Because I already knew it was going to take 2 or 3 live streams to cover all of these death penalty motions. So I think that's what we will do. We will save these for part 2, since they need to be all kind of in a batch. Or potentially I might just do it like a video that I upload, but probably not. I'll probably just do it in a live stream. So again, I will make sure to clarify or settle the times and stuff once I check with my students. Some of them have probably texted me back already since I started this, and lock down the times, but we will have part 2 of this potentially tomorrow, if not the next day. And whatever we end up doing tomorrow too, we will circle back to this idea here as well, where you guys can weigh in on how you want to go through that. But I think that'll have to be it for this one, because I can feel my throat going. And I think I pushed it a little bit too far last night, and it set me back a little bit too. But hopefully with each day, we'll get a little bit better here. I did go to urgent care today, and my lung x-rays looked great, they said. And they took some blood, but I haven't gotten the results of that back yet. But anyway, so they said likely it's just some sort of virus. But yeah. Yeah, so we will save this for next time, guys. So yeah, so I will check back in with you guys tomorrow, and I'm going to make sure I get plenty of rest. Y'all as well. Make sure you're getting rest and drinking lots of water. I need to make sure I do the water part too. Drinking it, I mean. And yeah, but y'all are awesome. Love y'all. And thanks as always for being here and for going through all these, funny, the saying going through the motions. Boy, that is very different in this context, right? I was going through all of these motions with me, right? Not like we're not going through the motions, but we're going through the motions, not like the saying. So I appreciate that, because it's important. It's important that we understand how this works and to see exactly how the government intends to execute people. Yeah. So y'all are the best, and love you guys, and I will see y'all next time.